2014-116, State of Arkansas versus Warren Willett. Court's making the appointment of the Public Defender's Office in this case for arraignment on charges of delivery of controlled substance, methamphetamine, Class C felony, with an enhancement provision for delivery near a facility.
And we've been in a plea of not guilty with formal reading of the charges and formal arraignment.
All right. This case is on the Division 4 docket, my docket, in which case the court's going to set it for a trial on November 10th and 11th. And this will be by written scheduling order. The pretrial will be scheduled for September 25th.
Judge, you will be faced in Marion County with a revocation warrant on this man. Same thing, you were the judge, and so you'll be the one assigned to hear that. He's put on probation the 15th day of August for 5 years.
All right. Well, I'm putting it down for his next reappearance in court over here will be for August 28th. Any other matters to take up at this time?
Your Honor, does the court show his bond at $3,500?
That's what it appears, yes.
Your Honor, visiting with Mr. Willett this morning, he has been in jail, I believe, for 14 days, 45 years old. Your Honor, I would submit to the court that a bond reduction of approximately half of this amount would certainly ensure his reappearance in this court as much as a $3,500 bond would, and we would ask for said reduction.
Judge, the bond is more than reasonable, especially in light of his criminal history. In fact, he's on probation. He's going to face another arrest warrant in a different county. I think that any bond reduction would be redundant at this point, and he at least needs to wait till he's healed from the revocation in Marion County before he seeks a reduction.
The only thing I would add is that this gentleman did turn himself in. He did not force the sheriff's office or anyone else to come and find him. He turned himself in voluntarily.
He continues to his drug problems. It escalated from possession to delivery now, which is not unusual with people who have drug issues.
Court's going to leave the bond at $3,500. That is a reasonable amount given the circumstances of this case and the defendant's the likelihood of the defendant fleeing. So on that basis, the court is setting the matter down for a $3,500 bond. Next appearance in court is August 28th. You may be excused, sir.
Thank you, Your Honor.
Next matter to take up is 2014-111, State of Arkansas versus Danny Sturgis. There apparently is also is this a revocation matter or just a failure to appear? There's also 2013-47, same defendant.
Judge, we're enter not guilty to the new charge, and I would ask that, well, to both charges, I guess, however we need to do. And I need to visit with the state a little bit on it. So I may ask the court to recall it.
Okay. I'm going to set it down. Both cases are on Judge Putman's docket, so I'm going to set it for a reappearance on May 8th in a week on both cases.
Thank you, Judge.
All right. You may be excused. 2014-112, State of Arkansas versus Robert Camille.
Then we would enter a plea of not guilty on behalf of Mr. Camille and waive formal reading of the charges, formal arraignment.
All right. This case is assigned to the Division 4 docket of this court and will be for jury trial, and there'll be a written scheduling order that contains all these dates. Be for jury trial November 10th and 11th. It'll be for pretrial on September 25th, and then the court will order the defendant to reappear on August 28th to check the status of the case. Any other matters to be brought before the court?
Your Honor, Mr. Camilli is being held, I believe, on a $15,000 bond. Your Honor, I think this is a matter that I need to visit with Mr. Kincaid about during a recess. This gentleman lives in Arizona and does not have Arkansas ties, so I need to visit with Mr. Camilli and Mr. Kincaid, I think, before I proceed further with a bond reduction request, Judge.
Judge, I'll advise the court, I think he's been under absconder status, plus we had to go through a formal extradition and bring him back. The state really opposed any bond reduction. Matter of fact, the court might want to consider increasing the bond. So I'll visit with Mark at the break.
Yeah, I'm going to leave the bond at the moment where it is at $15,000. I don't know where Arizona gets in the picture at this point. The information that's reflected in the affidavit is that he may have been in Florida.
Your Honor, may I speak?
Yes, I'll hear from you. I was just going to say we're not going to litigate the issue right now. I'm just trying to make some determinations here.
Yes, sir. I'm not worried about the bond. I don't have any money. My wife's got stage 3 cancer because we were heading to Florida to go to medical, and she got sick in Georgia, and I had to take her to the Northeast Georgia Cancer Care Center, which they did chemo and radiation. And she's got stage 3 cancer, and I'm her only caretaker. And we live out in the desert in Arizona because we can't afford nothing. We living on public land, and you don't have there. You got no water, no electric, no nothing.
What are you suggesting? Is if you were to be released on any basis, you're saying you're going to be living in Florida, Georgia, or Arizona?
We live in Arizona, sir. We can't afford nothing. We're living on public land.
Yeah.
Out in
I'm
Arizona.
just going to say there's certain, when you're in the status you're in as which requires you to register, the burden's on you. I'm sympathetic with your situation.
Yes,
but
sir.
The
I've
burden
talked-
is on you to make the arrangements to live where you're going to live, and your failure to do so.
Well, sir, the only thing I did is I forgot to tell him that I was moving out of the
Your
state
Honor,
of Arkansas.
I'm going to stop him now because he's getting into
Right.
what the court said he could not get into, and that's litigating his case. That's all we have in this matter at this time, Judge.
Okay. And I'm going to leave the bond at $15,000 and expect counsel to discuss that with the state, and we'll see where we are. All right.